So Judge Polaha?
Yes.
Okay.
I'm here.
Okay, just checking. Well, this being the time and the place for the continuation of the hearing in the matter of the Honorable Jennifer Henry, Hearing Master for the 8th Judicial District Court, Family Division. This is the Nevada Commission on Judicial Discipline. We'll introduce the members and then it will be presided over by Judge Jerry Polaha, who is in Reno, and he's here on our screen. I'll start with myself. My name is Gary Vause. I'm the chairman. I'm a lay member from Clark County, Las Vegas, Nevada.
Tom Stockard, District Judge, Churchill County.
Stephanie Humphrey, I'm a commissioner from Carson City, vice chairman.
Joseph Sanford, Commissioner of Carson City.
Karl, attorney member for Clark County.
Bruce Hahn, attorney member, Washoe County.
Falls Island, General Counsel, Executive Director.
Judge Polaha presiding up here, Washoe County, District Judge.
Okay, Judge Polaha, it's yours to conduct.
Thank you, Mr. Chairman. Good afternoon, and I want to thank you for accommodating me the way that has been done. And for the record, when we left last time, since then a motion was submitted by the prosecutor on October 28th, a motion for leave to amend formal statement of charges pursuant to NRS 1467 subsection 8. That motion was opposed by the respondent on November 4th, 2019, and the reply brief was filed November 7th, 2019. After that, we met as a commission and unanimously granted the opposition to that motion and denied the motion to amend. All right, so that is where the matter stands at this time. So I believe, Mr. Bradley, you were finished with your examination of the judge?
That is correct, Your Honor. And as I indicated in my motion to amend, I would like the opportunity to supplement my exhibits with the respondents' responses to determinations. I don't believe that the respondent is prejudiced by the delay in the request for admission of these documents. These are the documents that she and her attorney created. These are her own statements. The reason they became necessary at this point was that the testimony of the judge indicating that she was it was incorrect to refer to the disposition of juvenile AB as a sentencing, and in my papers I pointed out in the motion to amend that although you denied it, I believe it's relevant to the question of whether or not the judge really thinks there is a difference between the word sentencing and the word disposition, since she used them interchangeably both throughout her oral interview that is a record, or is part of the record here, and the responses to the determination. I have copies of the additional exhibits if they are admissible, or if the court would, or if the judge would prefer, I could wait and ask to have them entered as rebuttal evidence. It just seems more efficient if they would be admitted at this point in time.
Mr. Terry?
Polaha, members of the commission, I think that's more of a question for cross-examination. We would object to the totality of these documents being introduced. There's information in them other than what my colleague is indicating. I'm sure he recognizes that and I recognize it. So I think it's an issue that may be right for cross-examination when Judge Henry testifies, but not to be admitted for truth of the matter asserted within the exhibits.
You're breaking up. Can you hear me, everybody down there?
Yes.
Yes.
You want me
Yeah,
to-
Mr. Chair,
I broke up.
you broke up, yes.
Okay, I'll repeat myself. We object. This is more of a matter for purposes of cross-examination. There was other material that is set forth within those documents that is not relevant to the proceedings that haven't been adduced so far. And again, rather than having the totality of the documents admitted, certainly she is available for purposes of examination by Mr. Bradley.
All right, I'm going to defer admitting at this time, Mr. Bradley, and if you want to bring it in as a rebuttal, then we'll take it up at that time.
Thank you, Your Honor. Your Honor, at this point, I do formally rest the prosecuting officer's case.
All right. Mr. Terry?
May I address you and the members of the commission?
Yes.
And please tell me if I'm breaking up. At the time that we adjourned last time, there was a motion to dismiss count one and alternatively a motion to dismiss certain of the rule violations that were alleged within count one. The commission has now denied the motion to amend, so I would renew my motion to dismiss those rule violations. They are specifically 1.2, 2.3, 1.1, and 2.5. I believe when I addressed the commission the last time, I specifically addressed you on 1.2 and 2.3. In light of the ruling, however, I would like the commission to consider the dismissal of the totality of the rule violation allegations that are set forth in count one. And that was all I have, Mr. Chairman, Judge Polaha.
All right.
And I might tell you, as an example, Rule 2.3, failing to be free from bias. I don't believe there's been any evidence adduced at these proceedings showing any type of bias on behalf of Judge Henry. That's just an example.
You were asking to dismiss count one. Am I hearing that correctly?
I'm asking for two considerations. The totality of the dismissal of count one, and if the commission denies that, then the dismissal of certain of the rule violations that are alleged within count one. Specifically, Rule 1.1, 1.2, 2.3. And I think in good faith, those are the only ones that I can move to dismiss at this point in time.
All right, but again, that would call for the vote of the commission.
I understand.
And at this time, I will again defer that ruling until later.
Very well. Then, like Mr. Bradley, we're prepared to proceed, Judge.
Go ahead.
Okay. I will not give an opening statement. I will reserve for purposes of the closing, if that's permissible. We will call Judge Henry as a witness. And just so we're clear, as you might have noticed, I did not cross-examine Judge Henry, so kind of what I'm going to do is a combination of, but on direct, of examination of Judge Henry, but also respond to several of my colleagues' inquiries.
Judge Polaha, who do you want to administer, was she under oath? She's
She has not been
placed under oath, so who do you want to administer the oath of a witness?
Get ready.
There's a court reporter, she can swear them in.
Very well.
Do you solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, So help you God?
Yes.
Would you state your full name for the record, please?
Jennifer Henry.
And what is your current position?
I am a hearing master for the 8th Judicial District Court, Family Division.
For the benefit of the panel members and in support of our mitigation issues, would you please relay to them your experience within the juvenile court system and family court?
I was appointed as the Guardianship and Domestic Discovery Commissioner in September of 1996. I served in that position until about mid-2005, when I elected to take a transfer out of that department into the Domestic Violence Department. I was in that department for about 4 years, and in mid to late 2008, our then probate commissioner was retiring, and so the court did a scramble and decided that I was the most logical individual to go down and fill that gap while they were figuring out how to get the retirement bought out and to find a new individual. So I served in that position until about March or April of 2009. And then when I went back to family court, I was put back part-time into the domestic violence department, but also into the juvenile sex offense docket, which is a specialty docket of the juvenile delinquency branch of family court. Then at some point between 2000 and like maybe early 2010, I became a full-time delinquency hearing master, doing specialty docket of juvenile sex offense, and then just regular docket of ordinary delinquency acts 2 days a week. I ran some other specialty dockets that I developed throughout the years. Then October of 2016, this incident, I was moved down to the criminal arraignment hearing master position, and I served in that position from October 2016 until about July of 2017, when it was decided that I needed to go back to family court, to go back into the domestic violence department, but also to pick up a brand new project or docket called the guardianship compliance docket, because of the issues that happened mostly in Clark County, but statewide, with guardianship issues that made national news. And then I ultimately, earlier this year, went to child support enforcement.
All right, so you've been with the family court, and correct me if I'm wrong, is there a distinction between family court and juvenile court?
Juvenile court is a division of family court. Family court is a specialized court. It's not regular civil criminal. To be a member of family court, you have to have specific training. So for instance, if one of the judges was a regular civil criminal judge, they can't serve as a family court judge, but family court judges can serve as civil criminal judges. So you have to have some specialty training. Then within family court, to be on the juvenile delinquency bench, you have to have even more specialty training.
What type of specialty training did you have?
It was courses through the National Judicial College. Basically, you have to understand the juvenile mind, and that's not developed, and you have to be able to deal with not only parents, but have to know some of the resources that are available, not only locally, but also on a national level, with how to deal with children. It's just a whole different mindset.
You indicated that from approximately 2009 to 2010, you were involved in sex offense cases. Could you elaborate on that?
Well, actually, I was involved in sex offense cases from when I took when I went back part-time into the family court, domestic violence, and the sex offense. And I served clear up until October 6, 2016, so I did that for about 7 years. A juvenile sex offender is an individual that breaks, well, it sort of speaks for itself. They commit sexually oriented offenses. They have to be 18 years or younger, unless the court already has jurisdiction over them, in which case you can go up to the age of 21 to have jurisdiction. But if somebody commits a sexually oriented offense, then I was the hearing master that dealt with all those cases from beginning to end, unless there was an objection and the case went in front of Judge Boyd. So for instance, if an individual committed a sexual assault, then I took all the testimony, I got the disposition done, I put them into sex offense specific counseling as the representative for the court. When I say put, I want you all to understand that when I'm sitting there, I am the judicial officer, but my role is to recommend. The law and the local court rules are very clear as to my jurisdiction. I can only recommend, but when I'm sitting in that position, I'm the one that's doing the talking, so I'm the one that's saying I put them on probation or I put them into sex offense specific education classes.
Types of programs were and are available for sex offender victims, typically juveniles?
I'm sorry, can you repeat that?
What type of programs are available through the juvenile court system for victims of sex-related offenses that are juveniles?
Well, it's a little different if they're an SEY, sexually exploited youth, versus a sex offender. But we have psychosexual evaluations, then we put them into counseling. There's, depending on their age, there's different counseling. One's called Pathway, one's called Footprints, depends on their age. But they have to go through a series of counseling, then they have to take some tests before they can progress, and then there has to be a what's called an AXA. It's a specialty certified counselor that agrees that they have sufficiently been reformed so that they can be taken off of probation, off of oversight. With regards to a sexually exploited youth, we have Embracing Project, which is a specialty counseling project, a woman, very dynamic woman that works with one of our UNLV professors, Alexis Kennedy. They're renowned across the nation with regards to their understanding of sexually exploited youth. So they go into counseling, they're given wraparound services, they're given protection. Basically, when you're a sexually exploited youth, there's been something that's happened to you, or you've been groomed and indoctrinated into this whole philosophy, and so it's basically trying to break that philosophy, so that they're not being coerced or intimidated, and that they're free to make their own decisions and understand that they don't have to live that life.
Are oftentimes juvenile individuals that come in with some form of a charge against them that you make a determination are actually sexually exploited youths?
Yes, quite frequently. And in fact, right after this case, there was a case that came out in the Supreme Court. It's called AJ. Very similar facts. The girl came in as obstructing an officer. She was put on 12 months of probation, and then she was given some programming, but ultimately it came down to the fact that the district attorney was charging on these misdemeanors, which are basically lead-in kind of charges that are precursors to sexually exploited youth type behavior and charges. So the Supreme Court said, well, no, if they're coming in as sexually exploited youth and you know that's what they are, then they need to get the benefit of the NRS Chapter 62 provision that says they're victims and they're not delinquents.
Do you agree that the juvenile court system has its own terminology? As an example, a subject minor does not necessarily plead guilty, they admit the charges.
Correct, it does have its own terminology.
All right. And what types of programs are available for sexually exploited youths?
Well, we have the Embracing Project. This is basically counseling with some individuals that understand the indoctrination or the grooming and trying to break the grooming and trying to get them into households. A lot of times sexually exploited youth are runaway, so we have to get them fixed to the point that they're able to go back to their original jurisdiction.
So the juvenile court system isn't there to punish those individuals. What are they there for?
To educate, reform, rehabilitate, protect.
Family involvement with that?
In the perfect world, yes, but not always. I mean, a lot of these children are runaways, and so, you know, they come from foster homes, they come from abusive homes, they may not even tell us who they are for a while, so they go by pseudonyms until, you know, we can find out where they belong and get them back home if there is a suitable home to go to. Otherwise, they get put into placement.
In the case of A.B., there was a family involved, correct?
Her family was extremely involved.
We'll get into that in more detail. You also were responsible for developing certain programs down through the juvenile court system, correct?
Correct.
All right. Briefly, just tell the commission what types of programs you established that are still being utilized.
Okay, well, when I was specifically on the juvenile bench, I put into place juvenile restitution court. So it was something that was very novel. We had lots of children or juveniles that were on probation, and they were indefinitely on probation but without supervision because they still had outstanding restitution. And so in order to not only compensate victims, but also to get the children off of probation and to free up our probation officers for more important cases, I came up with a program where we started putting these cases where there was probation onto a mass docket. When I say a mass docket, all the cases were scheduled for one period of time. They came in, I put them on a payment plan, and then for like the first year and a half, I was a human calculator because the court didn't have a system for me to use. So I would put them like out every 3 months, and then I would come back in, I would go into the juvenile financial system that we have for our court, and I would actually do the addition to make sure that they made every monthly payment, and if they did, then they didn't have to come to court. If they didn't, they needed to come to court and speak to me to tell me why they were unable to make the payment. When I say they, obviously it would be their parents most of the time because they were minors and so they wouldn't have jobs, but their parents were responsible for the restitution or their guardians. So if they would show up and have a plausible reason why they couldn't make a full payment, then they were excused. If they didn't show up or they didn't have a plausible reason why they hadn't made their mandatory payment, then there would either be a violation of probation requested, or if they failed to show, then there would be a writ out for the child so that the payment would be made and the writ could be quashed.
Are you familiar with the statutes that deal with the juvenile court system?
Yes.
Under NRS 62A.180, juvenile court is defined as each district court judge who is assigned to serve as a judge of the juvenile court pursuant to a different statute or court rule. Is that correct?
Can you repeat that?
Sure. Under NRS 62.180, and I can show it to you if you need to, juvenile court is defined as means each district judge who is assigned to serve as a judge of the juvenile court pursuant to NRS 62B.010 or court rule. Is that correct?
Yes.
Okay. That same section, section 2, indicates the term includes a master who is performing an act on behalf of the juvenile court. You agree with that?
Correct.
Okay. You clearly, this hearing is showing you are not a district court judge, correct?
No, I am not.
You are a hearing master, correct?
Yes, I am.
Okay. As a hearing master, do you have limited capabilities as far as what you can and cannot do?
Yes, I do. They're defined either by statute or local court rule or by the judge whom I serve under.
Do you have the power to find someone in contempt?
I do not.
Do you have the power to sentence?
No, I don't.
Okay. This commission has heard the term recommend.
Mm-hmm.
Okay. And correct me if I'm wrong, but what you do is you recommend to the family court judge, being Judge Boy in this case's scenario,
Yes.
what you think the appropriate
Decision.
ramification should be,
Yes.
correct?
Yes.
All right. And Judge Boy is free to follow that, or he doesn't have to follow that, correct?
That is correct.
Now,
Mr. Terry, can I go back and tell the panel also? One of the other programs I did, which I think is very important, is I actually got the legislature involved while I was on the juvenile bench to put into place a mental health pilot screening program. Unfortunately, the state didn't pick it up statewide, but Clark County School District and a couple of the schools where we ruled it out was actually still using it, because in my opinion, mental health issues are a huge problem in the juvenile court. And it was a tragedy as far as I could see that it was taking these parents, having their kids get into the juvenile system, into the delinquent system before they could get any help. So I, along with our court psychologist, with the blessing of Judge Boy, got some local people involved and got a couple of assembly people to sponsor a bill, and it became a pilot program for screening. And we had this very dynamic UNLV professor that I had met who was very involved in this in the LA County School District, and so she started helping us, but unfortunately because the state didn't pick it up, we lost her as a resource because she went to a state where they were able to get the funding to do that. But I was very big on mental health issues with regards to minors, and so I put that program in place, and I'm proud of that.
is the juvenile court system designed to purely punish?
It is not meant to be punished at all. In fact, if you look at, I think it's the case of, I'm going to say DT, it says that certification is not punishment. So no, that is not the purpose. It is to help, rehabilitate, reform, educate, and protect so that they can be good, productive members of our community.
And when you talk about certification, that is when a a juvenile appears in the juvenile court system, but is eventually ordered by the district court judge, in this case the family court judge, not you, to appear as an adult.
Correct, I had nothing to do with certifications.
There is in fact a statute that deals with legislative declaration in reference to the juvenile court. NRS 62 capital A.360. Are you familiar with that?
No.
Let me see if I can refresh your memory. It says each child who is subject to the jurisdiction of the juvenile court must receive such care, guidance, and control, preferably in the child's own home, as will be conducive to the child's welfare and the best interest of the state.
Yes.
Does that refresh your memory?
Yes.
Further provides, one of the purposes of this title is to promote the establishment, supervision, and implementation of preventative programs that are designed to prevent a child from becoming subject to the jurisdiction of the juvenile court.
Correct.
Is that correct?
Yes.
Is that what your role is?
Yes.
Okay. So the role of the juvenile court and the role of the hearing master is not necessarily to punish. Isn't punishment the last resort?
Well, and once again, if you want to call it punishment, but the Supreme Court doesn't call it punishment. Punishment, in my mind, is something that the court's not set up to do, and that's what the legislature says. But if you want to equate certification to punishment, then that's fine. But once again, the Supreme Court didn't say that. Our whole purpose is to take the child, the juvenile, figure out what's going on in their lives that brought them to the attention of the court, and see if we can fix that problem, get them the help they need, and keep them in their environment with their family. So a lot of times, the programming and the help that we're giving is not only for the juvenile, but it's also for the family.
As a result of your experience, when you get a juvenile that's in front of you, are you able oftentimes to see an underlying issue?
All the time.
All the time. Is AB an example of that?
Prime example of that.
Okay, now, the commission has had the opportunity to view the, both the transcript of and the actual video of the appearance between yourself, Mr. Grigsby, and a deputy district attorney by the name of Karen James, correct?
Yes.
There was, however, a prior proceeding
Yes, there was.
involving the subject minor AB, correct?
Yes.
And Ms. James was present,
Yes, she was.
and you were obviously the judge.
Yes.
Okay, and when I refer to you as judge, please understand I understand you are a hearing master, but habits are habits, and I'm going to call you a judge. All right?
That's fine.
So, at the very first proceeding, Mr. Grigsby was not present, correct?
He was not present.
What was the first proceeding?
The first proceeding was the initial appearance.
Define initial appearance.
Initial appearance is where, initial appearance is where the family has agreed to bring the minor child back. The petition has been filed by the district attorney's office. You make sure that the family and the juvenile have the petition, understand the charges that are being alleged to have occurred, and then you appoint the juvenile an attorney. And in Clark County, every juvenile gets an attorney, everyone.
Now, AB, in this case, had she been arrested or had she received a citation, or both?
She had two charges. One was, I believe, a citation. The second one, she had been on the run for over a month, and she was brought into detention. When she came to see me for the first appearance, she was out of custody. She had been determined by our probation department to have not made what we call points to stay in there. So when a juvenile gets picked up, there's a risk assessment that's done by our probation department. And if it looks like they've got a family that can control them and they don't make points with regards to the severity of the charges that are facing them, the delinquent acts that are facing them, then they usually get released. And that is what happened. She was released, but then she came to see me out of custody because her parents signed what we call a return agreement, which is a contract that you agree to bring your child back to court.
In the juvenile court system, who makes the initial determination as to release or not release?
Well, in this case, it was probation, but if the individual doesn't have family that can come pick them up, or they are considered a higher risk and they make what we're called points and they get detained, then it is a juvenile hearing master that has a detention hearing and makes a determination whether there's a release or whether they stay, pending the charges.
So the actions by the probation officer in releasing, if I can use that term, AB back to her parents is consistent with the legislative declaration that I read to you a few minutes ago about the preferential treatment is to replace the subject minor back into the home.
Yes.
Okay. I'm going to address the commission at this point in time. At this point in time, we'd like to play the video that was involved with the first appearance pertaining to the subject minor AB. I'm going to make a second request. We have moved to exclude witnesses. Karen James, the deputy district attorney that was likewise involved in this case, is likewise present outside of these proceedings. I think it would save us some time if she were allowed to come in and view that first video for the limited purpose of just sitting here and viewing the video. If we don't do it that way, I'll have to show the video twice. I will not ask her any questions. I will direct her not to speak. I will walk her out after the video is over. Would that be acceptable to the commission and to the chair?
Is that for the purpose of refreshing the recollection, or what?
Actually not. It's so I don't have to show the video twice. She will testify in reference to the actions which occurred and what her interpretations were on video one, but it is not for purposes of refreshing her memory.
All right, I don't have any problem with that. But I have a question of the judge. Maybe you could clarify this, Mr. Terry.
Yes, sir.
It was my understanding that AB was not on probation, and yet I heard the explanation that the probation department was involved in picking her up. Now, was she on probation or was she not on probation?
She was not, and I don't want to answer Your Honor's question. I think it's better that the judge do, but I will suggest you, probation handles the release issue initially. And I'm going to ask you a question, Judge Henry, consistent with His Honor's directive. She was not on probation. AB was not on probation. And I believe that the transcript and the recording of the second video that you've already seen, Judge Henry makes it clear she is not on, she being subject minor, is not already on probation.
Okay, then how did she talk about the probation department bringing her in? That's what I heard.
Okay. I thought I explained that, but I'll ask Judge Henry to explain. You heard His Honor's inquiry.
Okay, so she got arrested by Metro. She was brought into our detention facility, which is in the back part of our family court campus. She was put into booking, our detention booking, which is run by probation. She was given the risk assessment by our probation department, and she was determined by our probation department not to make points, and she had her family come pick her up, and they being probation believed that the release to her family pending the return was appropriate.
All right, and this is done in every case?
Yes, it is, yes.
Okay,
And
thank you.
part of this is so you don't keep the juvenile in custody until there's a court date.
Correct, well, okay. So yes, and we also are what's called a JDAI, Model Community Juvenile Detention Alternative Initiative community, which means that we're trying not to keep our kids in detention if there is an alternative that is available. We're keeping statistics for, I can't remember I think it's called the Casey Foundation. It's a foundation that's sort of running these programs, and so we are one of the JDAI sites, and so we are doing everything we possibly can to get our kids home pending everything. We don't want them in detention if there's an alternative, because of some empirical data that's come out about how many days children spend in detention facilities. Does that help?
All right,
Your Honor, does that answer your inquiry?
yes,
Very well.
thank you.
Then may I take a moment and get Ms. James consistent with your directive while my colleague sets up the video?
Go ahead.
Thank you.
Judge Polaha,
Yes.
This is a juvenile proceeding that I think we'll have to, once again, clear the
Yes.
hearing room.
Because the name is mentioned.
Yeah, and they're probably there too.
In the face.
Yeah.
Yeah.
All right.
I make a finding that paternity has been established.
He was the potential to introduce children.
We're here for the court's order to show cause.
Okay, so that takes care of one motion.
We'll make sure that she's put on house arrest.
As you know, the Supreme Court has
Okay, why don't you give me the statute?
I'm not putting up with any of the crap here today.
Your Honor, you've just seen the video from 9/19 to 16 regarding the subject minor AV.
Yes.
Well, I hate to ask this question. What is a dick pic?
That was a big appointment.
They were both dick pic and dick appointment. I'll get the dick appointment.
Dick pic is a picture of genitalia. It's sent readily over usually text messaging, sometimes Snapchat.
Is that why you described to the subject minor about the repercussions of putting these types of pictures on the different social medias?
Correct, because that's considered sexting.
And this was information derived from the father.
Yes, it was.
Now, the second term that was used was dick appointment.
Correct.
What is a dick appointment?
A dick appointment is basically what it sounds like. It's an appointment to have sex with somebody that's usually not your boyfriend or girlfriend. It's a sexual act.
So you had a 15-year-old that was in court on some minor offenses, correct?
On the surface, yes.
Okay. Now, in different jurisdictions, this could have been handled in a whole different way, correct?
Yes.
Okay. Would you give the commission an example?
Well, if this information would have been readily available, as this case maybe went along, it might have been what we would consider a consent decree, because once again, becomes obvious that she's a sexually exploited youth. And there is a specific statute in 62, I think it's C, that says that we are not to treat sexually exploited youth as delinquents. We're to treat them as victims and get them on a consent decree, which is basically a hold open. So you're not adjudicating on the offense, but you're holding open a case. You're monitoring. It's called a monitoring order, which is one of the things actually that I devised for our court, was the actual language of the monitoring order, so that we had jurisdiction over the child, but we weren't putting them into the delinquency program per se. That answer your question?
Yes.
Okay.
Now, you also had a conversation with her in more of an informational situation by you to her in reference to the phone, social media, computers, etc.
Yes.
What was your intent there?
Well, it was to scare her, but to also make her understand that what it looked like she was doing was extremely dangerous, extremely dangerous.
Now, I'm going to go into the hearing that involved Mr. Grigsby. The panel has had an opportunity to see that video. We will not replay that at this point in time. What was the purpose of that hearing? And again, to remind you, the commission has a copy of the transcript which has been admitted and they see the video. But what was the purpose of that hearing?
Well, the first hearing was to figure out what I needed to do to get from point A to point B. So point A was the first appearance, the appointing the attorney. Point B would be the second hearing where Mr. Grigsby was appointed as her attorney, and that was the actual entry of plea.
Okay. So when Mr. Grigsby is appointed, do you appoint him?
Well, she was originally appointed the public defender's office, so it's just a blanket, go to the public defender's office, and they're on a rotation. Somewhere underneath the scene, and I don't know where that happened because it wasn't me, so I don't think I did it. It was determined by the public defender's office that there was a conflict of interest, and so Mr. Grigsby is one of the contract attorneys that takes on the conflict cases when the public defender can't be appointed.
The potential conflict of interest was due to the fact that there were multiple juveniles that were either arrested or cited originally with the subject minor AB, correct?
Correct, and one or more of them would have had a public defender as their attorney already.
All right. So when you went into that hearing, what was your intention?
Which hearing?
The second hearing.
Well, to take the entry of plea.
Right. And did you do that?
Yes, I did.
As you did that, did you question what the facts were that supported the underlying plea?
Yes, because you have to have the sufficient factual basis to determine that somebody's committed a delinquent act and determine that they're a delinquent.
Now, Ms. James, who just left the room, was present during what I'll call the first video. She was likewise the deputy DA at the second proceeding where Mr. Grigsby was the attorney, correct?
Yes.
So she had been there for the whole case, correct?
Yes.
There hadn't been any court proceedings between the first and the second video, correct?
No.
So did it appear to you that the case was resolved, negotiated?
It was negotiated.
All right. And what did that mean to you?
Well, negotiation is as to what charge is going to, or delinquent act is going to be admitted. So she had two petitions, one that had come in on a citation, I believe, and the second one was due to the arrest. And the two attorneys had decided that they were going to dismiss one count and have her plead to the other.
Now, there were certain procedures that had occurred in the interim, whether or not a report had been generated, for example.
I'm not sure I understand.
Any type of a report generated regarding the risk management situation of the subject
Right, there's
minor?
something called an SAS. It's a summary assessment, and it's basically done before the first appearance. So what will happen is when the parents come in and they get the child back, which was the release to the parents because she didn't get points when she was in detention, they get a lot of background information on her. And at that time, probation sort of lays out what terms and conditions they think is appropriate for that child to have. But that happened prior to September of September 19th date. My hearing with Mr. Grigsby was on October the 10th, and so she had been released home, so there was a period of time that I needed information as to how she was doing.
Now that SAS report is described as available to the district attorney,
Yes,
you,
yes,
and Mr. Grigsby.
yes. However, it's not always just given to me, but most of the time I've been able to see it. It's not part of our case management system. It actually, it's a work product that belongs to probation, but the judge has the right to see it, as does anybody that asks, as far as I know.
You understand that Mr. Grigsby's already testified, and if my recollection is correct, he testified that he hadn't seen the SAS report.
Objection, that's not accurate.
If it isn't, I apologize. I'm basing that on recollection.
Well, I believe he
I'll withdraw the
testified.
question.
Okay.
To your knowledge, had Mr. Grigsby seen the SAS report?
I don't know, other than what he said.
All right. Would the SAS report have also indicated the sexual exploitation that you testified to, that you believe you observed from video 1?
Potentially.
Okay. Now, what was your function at that second hearing? What was your role?
My role was to take the plea and then decide the appropriate disposition, meaning whether I accepted the plea because there was sufficient factual basis to do so, and then to determine what the appropriate disposition would be, which are terms and conditions of probation. But once again, I recommend.
And just so we're clear, the young lady was not on probation when she appeared in front of you on the second?
She was not on probation, no.
Okay, so there was no potentiality of a probation revocation procedure or anything like that because she wasn't on probation?
Correct, but we don't revoke probation in juvenile. It would be a brand new petition.
Now, when you make a recommendation, do you state that recommendation on the record?
Yes, I stated very succinctly on the record with all the terms and conditions that I believe are appropriate for that particular juvenile.
But you were not able to make a recommendation in this case.
Objection, Your Honor. The JAV's video speaks for itself about what she was able to do and not able to do.
And we agree with that. And I believe the Jazz video shows she was not able to make a recommendation.
And Mr. Grigsby even
Yeah,
testified to that I didn't make.
I agree with that. The video speaks for itself, and that's already seen.
Very well. Okay. Did there come a point in time when you were questioning the subject matter?
Yes,
Did you understand Mr. Grigsby to invoke her Fifth Amendment rights?
no, not at all.
Did Mr. Grigsby ever use the term, Your Honor, we invoke my client's Fifth Amendment rights?
Objection, same, Your Honor. Asking what was said and what wasn't said on the video.
I'm going to go into the judge's state of mind at that point in time. That's why these preliminary questions are being asked.
Yeah, go ahead and answer that.
What was the question?
Question dealt with,
Oh, whether he had said the Fifth Amendment? No,
Correct.
he never said the word Fifth Amendment. In fact, he never objected. There was never the word object, which I noticed the formal statement of charge uses the word object and objection over and over again. In my opinion, objection is a term of art. It's a legal term of art. An objection is I object, foundation for the objection, and he never objected.
when a lawyer appears in front of you, do you expect him to follow the basic rules? For example, when you make an objection, you say objection, and then you articulate what the basis of your objection is.
Yes, and
Did that occur in this case?
No, not at all.
Okay. What information were you trying to elicit from the subject minor?
I was trying to find out after her parents told me that between the time that they had seen me at the first hearing in September, where I had her on GPS and home management with DRRP officers. DRRP is Detention, Release, and Review Program. When we have a child.
Judge, you're going a little fast.
Okay.
Slow it down.
Sorry, I'm a fast talker and.
Don't be.
Okay. Well, I'm a trained
Repeat your
auctioneer,
answer.
so I'm just speaking very quickly.
Are
Anyway.
you done now?
No.
Answer.
Okay. So DRRP is Detention Review Release Program. So not only do we have a child on a GPS, We also have a set of officers that do random check-ins on the minor. Are they at school? Are they, at home? If their GPS goes off, they're the first ones that go out and find where the child is and round them up and bring them into detention.
So, the purpose of your asking the question of the subject minor, was it criminal in nature?
No, I was trying to figure out what she was doing. So my question to the family was, after she's been under the watchful eye of the court, have there been any problems? And I learned, yes, there have been problems. And the problem was that she had a cell phone at work, or at school, which from the first hearing, the parents told me that that's how she was getting somebody to come pick her up and run away and stay away for a month at a time. So as soon as the word cell phone came out, I was like, oh my gosh, I have a huge problem here.
Well, why were you so concerned about whether she did or didn't have a cell phone, or was using a cell phone?
Because that's how she was communicating with whomever was coming to pick her up, and that's how she was making dick appointments. That's how she was involved in the sexually exploited youth arena.
The commission has watched you on that video, and at points in time, you tell Mr. Grigsby, enough.
Mm-hmm.
What manner of control do you have in that courtroom, recognizing you've already indicated you do not have the contempt power, and you're merely making recommendations to Judge Voigt?
Basically, I have the ability to get the floor back by raising my voice, or I have the ability to cut the momentum of what's happening off by taking a break. I don't have contempt powers. I can't make an order.
Was it your intent to cut Mr. Grigsby off so he could not address the court?
No.
Did you give him an opportunity to address the court?
He continually addressed the court.
Did he in fact interrupt you?
Yeah, he did.
Did you at times speak over him?
Yes, that's what a judge does.
But you were the hearing master,
I
correct?
was a hearing master, but the floor should be mine to direct the hearing how I need it to be directed.
Very well. Now, you also took a break.
Yes, I did.
What was your purpose in taking a break or a recess?
Was to stop the momentum of us not getting anywhere, and so we could all regroup and come back, but it was a control mechanism.
From viewing the video, it was less than a minute that you took that break, correct?
Yes.
All right. When you came back on the bench, did you make that same inquiry of the subject minor?
I did. I wanted to know what was going on with the cell phone at school.
And she did not answer.
Actually, she did.
What
She
was
tried
her answer?
to. She started to say, and Mr. Grigsby talked right over her.
But she did not answer other than
No, she was not able to answer her, so he wouldn't let her. And
Same objection, Your Honor. We're talking about what happened on the video again, and I think that counsel and the witness should be instructed not to describe what happened on the video, because the best evidence of what happened on the video is the video, and it's already been admitted in evidence.
I'm trying to ask her to explain her actions and why she did certain things like take the recess. But I will try to refrain from repeating what is already depicted on the video, other than by way of an introduction to the format that I'm asking.
All right, go ahead.
But I actually heard her say, she tried to speak to me, so I'm not talking about what the video shows, I'm talking about what I heard.
You also had a concern that there was a factual basis for the entry of the plea, correct?
Yes, I did.
And did you inquire, why did you inquire of the DA what the factual basis was?
Because I wasn't sure, police officers walking up to a juvenile is not a delinquent act. So I wanted to know what the surrounding circumstances were that brought her into the view of the police in the first place.
Do you consistently advise a juvenile who is represented by counsel of the rights that they're waiving?
Yes, that's the standard script.
The only right that a juvenile doesn't have that an adult has is a jury trial right, correct?
Well, actually, there are some more, but generally.
Okay. Part of what you advise them of is the Fifth Amendment right, correct?
Correct.
And you indicate that they're waiving that, correct?
Yes.
Why do you do that?
Because they have, well, first of all, this was an entry of plea that was negotiated. But they do have the right to take it to a contested hearing, which in the adult arena would be called a trial. The DA has to prove the facts against them, and they need to understand that they're not required, when the DA is trying to bring the proof to show the delinquent act, that they don't have to incriminate themselves by giving that information to the district attorney. But in this case, it was a negotiated plea, and so we went straight into disposition after I took the plea.
There came a point in time when you were moved from the juvenile court to what is referred to as the lower level, correct?
Yes,
And that was due to Judge Voigt.
yes.
And was there a meeting where you were directed to go down to the lower level? When I say go down, it just means go to a different court other than through the juvenile court.
Yes.
Okay. Did you have an opportunity to view that video, either video 1 or 2 that we've seen?
I asked to have a copy of the video so I could respond, and I was told no.
Okay. Did you have an opportunity to explain what had happened in reference to video 1 and 2?
Absolutely not.
So it was a come on in and we're sending you to the lower level.
Yeah, it was basically come in, sit down, this is what's happening, take it or leave it.
Okay, what other punishment did you receive?
1 week unpaid suspension.
Right. Now, how long were you down in the lower level?
October 2016 until July 2017.
And what did you do on July 2017?
I was asked to go, well, I was told I was going back to the family court to serve in the domestic violence department.
And just so we're clear, you just created a distinction between told and asked. Are you an at-will employee?
Yes, I am.
You subject to being terminated at any point in time?
Yes, I am.
Without recourse?
Yes.
And without reason?
Yes.
Okay. So now you're back down to the juvenile court system, correct?
Correct.
And you have remained down there since that point in time?
Yeah, the larger family juvenile division, yes.
And as of today, obviously not today, but as of this week, what are you doing? What
Child
is your-
support enforcement.
Okay. That is different than the type of action that we've seen on video 1 and 2, correct?
Correct.
Okay. Was that a punishment?
No.
Okay. So you're simply assisting the court system with where you're needed?
Correct.
Now, you also had a chance to look at the original complaint in this case, and I'm going to ask you some questions in reference to the rules.
Okay.
Okay? In count 1, the allegation that you engaged in acts or a combination of acts by sentencing the juvenile to a harsher sentence. I'm going to stop there. Number 1, did you sentence the juvenile?
No.
Number 2, did you give her a harsher sentence?
No.
My colleague is going to say to you, the recommendation was for 6 months probation and you made it 9. What was your reason?
Because in disposition, a judge or the hearing master is allowed to take everything that is particular and important to that particular individual. Juvenile court is very different than adult court. We don't have grids that we go off on. We are supposed to make this juvenile specific with regards to the things that are going on in that family's life and that juvenile's life. It is supposed to be a holistic person approach to dealing with a delinquent act. So I heard everything her family had to say, and I still had a very large problem. In the first hearing, I don't know if you all heard it, but when her dad was telling me what she did, I said, wow, under my breath, which would be basically like, oh my gosh, I have a huge problem here with this girl. It's an excited utterance. So I heard what her parents had to say. I really wanted the juvenile to be able to talk to me because I had promised her in the first hearing that she had the ability to talk to me, but Mr. Grigsby wouldn't let me find out what was going on. So based upon that, taking reliable, not highly suspect, not improbable information from her parents, very reliable parents who were very informed, I knew I had a problem. And in juvenile court, I can give anywhere between 6 to 1 year of probation period as needed, and because I had her already under my watchful eye, the court's watchful eye, and she still was drawn to that cell phone, she still was drawn to that activity, I had to do something. So when I have somebody, when the court has a child on a longer period of probation, you have more opportunities to get them into help and to have that reinforcement that if you mess up, you're going to continue to be under the court's eye. So in Clark County, and I don't know how it is in any other jurisdiction, there is quite a lag between the time that the juvenile sees me in court and probation is able to get them into services. So if it takes 3 months in Clark County for all those services to be put in place, then really she's only under probation's eye for 3 months with any help. So you have to gauge what you're dealing with and give the appropriate outcome, which is what I was attempting to do.
Now, in looking at the rules, the first rule that you're alleged to have violated was failure to comply with the law. Do you feel you failed to comply with the law?
No, not at all.
Explain to the commission.
Well, in fact, we had a very long discussion, the first hearing about the Fifth Amendment. I understand the Fifth Amendment. I taught our peace officer state training to probation for Clark County Court, and my subject matter was constitutional law. And in this case, we were in disposition, and juvenile delinquency law is very, very different than adult law. And quite frankly, I was not asking a Fifth Amendment invoking or I was not running amok of a Fifth Amendment, because there are cases out there that say what happens in juvenile court with regards to disposition, and there's even an adult case that I did not run amok of. My full focus was on this girl and keeping her out of the sex trade. She was already in it, which became known later on. But no, I knew the law. I was doing what I needed to do to protect, educate, rehabilitate this child. And quite frankly, if I would have known more and had been given more information, that whole case might have gone differently. She might have been on a consent decree. We might have had a discussion about putting her outside of her home because of the people she was actually involved with at that time. I mean, her parents, she might have been in the Embracing Project with regards to sexually exploited youth. There were a whole myriad of things that might have gone differently if I would have known the answer to that question.
You're also alleged to have violated Rule 1.2, failure to promote confidence in the judiciary. Do you agree you have a duty to the public to promote confidence in the judiciary?
Yes.
At any time did the parents say to you, we disagree with what you're saying?
No, in fact, they said, Judge, we need an order from you to help us.
So do you feel that you violated Rule 1.2?
No, I know my job. I was applying it as this girl needed it, and her family needed reinforcement because they were having a hard time keeping her safe.
You're also alleged to have violated Rule 2.2, failure to uphold and apply the law, and failing to perform all duties of your judicial office fairly and impartially. Do you feel you violated that rule?
No, not at all.
You're also charged in count 1 with violating Rule 2.3, failing to be free from bias. I will skip over that rule, but briefly, did you have any bias against this subject minor?
No, not at all. In fact, I was trying to help her. I was very afraid for her well-being, and rightfully so.
Did you have any articulatable bias against Mr. Grigsby?
No.
Rule 2.5, failing to perform judicial and administrative duties competently and diligently. I don't think we're dealing with a lack of diligence in this case, but that's what the allegation is. Do you feel that you violated this rule in that you did not act competently or diligently?
No, because I go to court on time. I brief my files ahead of time. If there's anything that sticks out with the subject matter that I think needs to be addressed from the first hearing, I make notes on it. In fact, in this case, the first hearing I was sending a note to my clerk because I wanted some information that I knew she would know regarding this minor child from the first hearing that was not in the court minutes. So no, I was definitely, on the bench doing what I needed to do, and I understand the law, and I was trying to assist this family and this girl.
In reference to count 2, you are charged with some of those same rule violations, but you're additionally charged with a violation of Rule 2.6, capital A, failure to accord a lawyer's right to be heard. You feel you violated Mr. Grigsby's rights to be heard?
No, not at all. In fact, he had quite a bit of things to say, even to my back after we had taken a recess. He had plenty of time to make his record.
Did you hear him say, in essence, take as many recesses as you want?
Well, I believe, yes, he sassed back to me after I called a recess and I was on my way out. And then later, he also made an interesting comment about, well, you know, if I go over to see Judge Boyd and he says, do this, then I will, but I'm not going to do it for you.
Now, he also did not wait for you to make the recommendation before he articulated on the record that he was going to Judge Boyd.
Objection, same objection, video speaks for itself.
Well, does the video say that?
Sustained.
Very well. You're also alleged to have violated Rule 2.8, capital B, failing to be patient, dignified, and courteous. Before I ask if you violated that rule, do you feel that a lawyer has a duty to you to be courteous?
Yes, and in fact, I think the way that rule is written, if you take the whole thing, is that it's a dual thing, that one and the other have to be equal. It's not one period, the other period, or it's an and. So I think that it calls for complementary action. So if one person's doing one thing, the other person has the same ability to do that, if that makes sense.
Now, you feel you violated that rule in reference to Mr. Grigsby?
No, I was trying to make a record. My job is to sit and to hear a case from beginning to end and to make recommendations, and I was not able to get to the end to make my recommendations.
All right, now I'm going to turn to your verified answer, which set forth the mitigating circumstances, okay, that the commission has them. You have no prior disciplinary record either as a lawyer or as a hearing master, is that correct?
That is correct.
Okay. There was no dishonest or selfish motive in this case, correct?
Correct.
You didn't financially gain from what you did, correct?
No.
In fact, you financially lost from what you did.
Yeah, I absolutely did.
And you cooperated fully with the Judicial Ethics Panel,
And then some, yes.
including interrogatories, including an interview, answering questions, etc.
Yes.
And the commission has certain character letters dealing with you,
Yes.
which I know that they will take into consideration. Now, we've listed number 5 as interim rehabilitation. Perhaps the terminology is incorrect. Have you taken additional CLEs regarding court management, etc.?
I fulfilled the CLEs. In fact, I fulfilled all of my next year CLEs and part of them into 221. So yes, I've taken many, many CLEs. I've also had a big opportunity to reflect on what's happened too.
Now, oftentimes judges are invited or required to attend certain types of seminars. Can you attend those?
No,
Why?
because I'm not a judge. And in fact, prime example, today there is a big meeting of all the district court judges in Clark County at UNLV, and yesterday our chief executive officer secretary sent an email to all the hearing masters saying, this is for judges only, you as a whole group are not invited.
And you acknowledge that there were, as you testified to, the imposition of other penalties and sanctions.
Yes.
You allege that you are remorseful, but you indicated that you do not feel that you violated any of the rules.
Correct.
Is that consistent to be remorseful, but yet to suggest to this commission that you didn't violate any of the rules?
I guess so. I mean, it's very regrettable that we're all here. My sole purpose was to assist that girl and that family. I was trying to do my job. I told the girl she had the right to talk to me. I was actually in the disposition phase, which if you analogize that to the adult court, the child has the right to speak. It's very clear, 176.015 is the attorney can speak and, not an or, and the minor can speak, the defendant can speak. Everybody's allowed to mitigate their circumstances, and I was taking into consideration what her parents had told me. Her parents told me that she was still on the cell phone, that she was, they were afraid she was gonna run, and so I didn't think that I had any other thing to do other than to give her 9 months, but she had the right to talk to me before I did that. In adult court, you get something called a PSI, a pre-sentence investigation report. Every adult has the right to refute, discuss, or disagree with what's in that pre-sentence investigation report. In juvenile court, there is no such thing. I am the pre-sentence investigation report. My questions are the pre-sentence investigation report. So if I'm asking the parents, and the parents say X, Y, and Z, then the minor child, before I pass judgment, should be able to respond to those points. And that's where I was in this case. This had nothing to do with the Fifth Amendment. We were beyond that.
In the respondent's amended exhibits that we provided to the commission, there are 3 separate sets of documents. They are the Violence Intervention Report for 2018, the Guardianship Compliance Case Reports for 2018, and your own performance evaluations.
Correct.
Have you ever been evaluated, received an evaluation as an underperformer?
No.
Have you always gotten the raises that were applicable for the next step for your duration of employment?
There's a range, but sometimes I've gotten way above the range. I've gotten a couple of bonuses for improvement to the court system for a couple of things that I've done. The year that this happened, I didn't get a full raise, so I was punished another way there. I got basically the cost of living equivalent.
For the record, those are exhibits I and J, all the performance evaluations that we were able to obtain, correct?
Correct.
Okay. Now, what is significant about the Violence Intervention Report and the Guardianship Compliance Report?
Well, those just show the magnitude of cases that go through my department. Those numbers are very high. I'm a hearing master. We do not have a law clerk. We don't have our own marshal. I share a secretary. So basically, I'm a high volume court, but I have to do all my own research. I have to get all my own cases ready. I pretty much am self-sufficient. But what that also shows is once that I went back down to family court, that I was doing 1/2 of the domestic violence caseload, exactly 1/2, plus I was given, because of my past knowledge and I'm gonna say expertise in the guardianship arena, a whole new project to figure out what to do with. And so I was not only doing 1/2 the caseload, but I was pumping out in my quote spare time, which wasn't spare time, all these synopsis and recommendations for the judges to get our guardianships under control, which is extremely time-intensive process. So just so everybody understands, I mean, I worked a lot of hours, and the only day that I had out of court to ever work on that guardianship was Fridays, and I spent most of my Friday evenings at the courthouse by myself up to 9 o'clock at night, so that I could stay on top of on top of what I was told my job was.
And one more time, how long have you been in the juvenile court system?
I have been a hearing master now for over 23 years.
Mr. Chairman, members of the commission, I am about done with my questioning of Judge Henry, but I wonder if I might take a 5 to 10 minute recess.
I'm sorry, was that to me?
It was actually, I said Mr. Chairman, so it was Mr. Vause, but I recognize that you are the presiding officer, Judge.
And what's the request?
5 to 10 minute recess.
All right, go ahead.
Thank you.
Is everyone ready?
Yes, Your Honor.
Yes, Your Honor.
All right, then let's get back into session. And let me remind counsel that our deadline is 4:15. That's based on stipulation that we'd only need so many hours. All right? So you may continue.
I have no further questions of hearing Master Henry.
Mr. Bradley?
Thank you. Master Henry, you're aware that you have a duty to cooperate and be candid with the commission, correct?
Yeah, absolutely.
And the commission asked you to answer interrogatories in this case, is that correct?
Those interrogatories were stricken, counsel, by stipulation between you and Mr.
I didn't ask if they were admitted, I asked if you answered them.
Yes, I did.
And one of the requirements when you were asked to answer the interrogatories was that you answer them under oath, correct?
That was what the letter I received from Mr. Dyler was, yes.
Do you have any objection to the fact that you were asked to do so today? Do you object to the fact you were asked?
To do what today?
I'm sorry, I'll start again. Do you object to the fact that you were asked to answer interrogatories under oath?
Well,
Objection, irrelevant.
Yeah, relevance counsel?
I just wanted to know if she had an objection to that. If you don't think it's relevant, I'll move on.
Move on.
Thank you. On January 7th, 2017, you were interviewed by the commission's investigator, correct?
I'm not sure the date, but I was interviewed, correct?
And you were asked a number of questions, correct?
Yes,
And you understand the importance of providing honest, correct answers, correct?
yes,
You knew the commission was going to review those transcripts, correct?
yes.
You were asked the following question and gave the following answer. Question, knowing what you know now, would you have handled this any differently? Answer, I probably should have said, you're right, Mr. Grigsby. Just go see Judge Vause because I know you think I'm a piece of shit. That's probably what I should have done. That's the answer you gave, correct?
Yes, that was the answer I gave, but you need to understand that I was not provided a copy of the video from Judge Vause. I was not provided a copy of the video from the interviewer nor the commission until I was asked to answer interrogatories. I got to see the video in the presence of the investigator on a laptop that's maybe 12 inches large. The microphone was the size of a shot glass, and it sounded like I was listening to the recording through wax paper. Remember when you were a kid, you take a comb in the wax paper? That's what it sounded like. And I was not told whom had filed the complaint, nor was I provided with a copy of the complaint. So I went into that interview, no basis, no nothing, and I cooperated. And at that point, I figured it was Mr. Grigsby who had filed the complaint because Judge Vause had assured me in the meeting where I was told to take the transfer, be happy, that there was no other repercussions coming from that, and that was the totality of what was going to happen to me. So I happily took the transfer versus resigning. So when you're blindsided and you have no idea what you're talking about and you have to make assumptions, I was very upset. And when I found out later it was Judge Vause that did this, can you imagine? Talk about detrimental reliance. So I was very frustrated because I didn't know what was going on. I wasn't allowed to have any information. I was answering completely off of memory, and this was one of the most. There's been 2 horrible times in my life. This was one of them, and when my mom died this February, that was the second one. Horrible. I spent my entire life for the court. I have sacrificed so much for 23 years, and I have done so much for the court and for the community for 23 years. I got a domestic violence bill going, AB 194, so anytime that in an extended protection order hearing, that a judge wants to take a firearm,
Excuse me, Your Honor.
that's me and
do not
all
think
me.
that the
Go ahead.
the answer.
Next question.
Thank you.
Master Henry, couldn't we agree this answer where you swear to the investigator demonstrates your lack of respect for this commission's proceedings?
No, not at all.
Those are all the questions I have, Your Honor.
No follow-up, Mr. Chairman. I'm sorry, Judge Polaha, members of the commission.
You're finished?
Yes.
All right. You may step down.
Thank you.
call our next witness, Judge Polaha.
Go ahead.
Gary Vause. May you step out and get her?
Yes.
Excuse me, Your Honor, but before Mr. Terry does so, I'd like to remind the Commission and Judge Polaha and Mr. Terry that Ms. James' testimony has been the subject of a motion in limine where Judge Polaha ruled on February 28, 2019, that her testimony is limited to how the juvenile system works and SEY youth. So I am requesting a advance limiting instruction be given to the witness that her answers should not, one, express an opinion regarding what happened at the October 10th, 2016 hearing involving AB. Two, she not express an opinion as to whether it was likely or unlikely that AB could face additional charges had she answered Master Henry's questions and incriminated herself. And three, express any legal opinion regarding the Fifth Amendment, including when a juvenile may properly invoke the privilege and how an objection should be phrased. Those are things outside of what this Commission has already said must be limited to how the juvenile system works and SEYU.
And in response, I think I should be allowed to, and I'm familiar with Judge Polaha's ruling and the Commission's ruling. I should be allowed to ask Ms. James certain particulars in reference to this case as to the preparedness of Mr. Grigsby, which she has personal knowledge of, and quite frankly, what her view was of his appearance before the judge and the hearing officer, and whether or not she believed that the Fifth Amendment was being invoked. But I will yield to the prior ruling. I will ask that area of questions. If I deviate, I'm sure my colleague will object.
Your Honor, she was not offered to testify regarding Mr. Grigsby's lack or level of preparedness, and had I been notified, I would have had him available for rebuttal, and because I was not informed, he's not available for rebuttal. So I would request that that area not be allowed. And with regard to certainly whether she thought the Fifth Amendment was being invoked, her opinion is irrelevant. It's up to this Commission to decide whether or not it was properly invoked, and she's not.
Yeah, I agree with that. Yeah, it was my understanding that she was going to come in as a sort of an expert witness to explain the juvenile system and how it differs from the adult system, because the Commission is mainly used to having the adult system involved in our proceedings. You listed 1, 2, 3 items, I believe, Mr. Bradley. That second item that you mentioned, whether or not somebody can be held accountable for what they say at a dispositional hearing, I am not too clear on that. If there is a pattern set and established in the juvenile division where nothing happens in the exercise of the allocution of the juvenile at prior to the disposition, yeah, then I think that's a fair question. If it's not, then I agree with you that we shouldn't inquire into that. But otherwise, the other points I sustain.
Your Honor, and with regard to the pattern, I don't object to in general. I just don't want express opinion by Ms. James as to what would have happened in this case.
Well, this case is part of the general if they establish the general.
I think her opinion about what could be faced in this particular case is separate from what she was offered up as and limited to, which is how the system works in SEYU. She was not offered to render an opinion about what would happen in this case if she had incriminated herself. So that's separate from the offer and separate from what you ruled upon.
Well, I think Judge Polaha is right. I certainly have the right to ask her. In the juvenile court system, even in a response to a judge's question, whether or not there is a criminal charge that will be lodged against them.
And I think that calls for speculation, and I think it's an improper question for her to speculate as to what would happen in this case, had she answered the question. We don't even know what the answers to those questions would be, and it would be improper to allow her to speculate on what would have happened in this case.
She was a deputy DA for an excess of, a chief deputy district attorney for an excess.
Well, hold on. It's my understanding that you're gonna bring her in as an expert in juvenile proceedings. And if in juvenile proceedings, as a prosecutor, the situation arises in other cases as we are dealing with, and nothing happens, yes, I think that's relevant. If it's a case-by-case basis, yeah, then it's not relevant. I don't know what the answer is, but we'll find out as we question. But otherwise, your motion in limine is reaffirmed.
And I just wanted to bring it to the commission's attention that we were not notified that Mr. Grigsby was going to actually be a witness until right before the start of what I'll call the first part of the hearing.
I can't hear you, Mr. Terry.
I said we were not notified that Mr. Grigsby was going to be an actual witness until shortly before the first hearing. So when we made our proffer that Your Honor ruled upon, that was at the time that Mr. Grigsby was not going to be a witness. We got the notice of him being a witness at a later point in time, so I think the facts have changed.
In any event, Your Honor, it's not relevant what level of preparedness by Mr. Grigsby. The question is whether or not this judge violated the judicial code. And
Yeah, I agree. Go ahead.
All right, I'll bring Ms. James in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Would you state your full name, spelling both names?
Karen James, K-A-R-E-N-J-A-M-E-S.
And Ms. James, are you an attorney?
Yes, I am.
And were you employed? Were you employed?
Yes.
You are now retired?
Yes.
You retired from the district attorney's office?
Yes.
How many years did you serve with the district attorney's office?
27 years.
How many of those years did you spend in the juvenile court?
24.
Almost the full amount.
Yes.
So we would assume that you are exceedingly knowledgeable in reference to juvenile court proceedings?
Yes.
Are you familiar with Hearing Master Henry?
Yes.
You're familiar with Mr. Grigsby?
Yes.
You had the opportunity earlier today to watch a certain video where it was an appearance by a subject minor by the name of A.B.
Yes.
And Judge Henry presided over those proceedings, correct?
Correct.
And you were the chief deputy district attorney in that courtroom.
Yes.
What is the difference between a deputy district attorney and a chief deputy district attorney?
There's certain qualifications. It has to do with the length of your service, but there's also certain hurdles that have changed over the years that the district attorney makes that you have to qualify in order to reach that level.
And in your experience, did you become familiar, because of your experience, with subject minors that are oftentimes put into a position of being involved in prostitution-related activities?
Yes, we call them SEY.
You beat me to that one.
Okay.
I was just going to ask you. What is an SEY?
It's an abbreviation that it stands for sexually exploited youth.
And what is a sexually exploited youth?
They're primarily females, young girls, I've seen some as young as 11, who are normally recruited to sell their bodies for money.
In the proceedings, the video of which you had an opportunity to watch today, was your attention directed to both the comments of the father and mother of the subject minor as well as the minor?
I was primarily, I believe it was the father and the stepmother, by what the father had said about what the behaviors his daughter was engaging in, as well as I believe it was the probation officer who spoke about her runaway behaviors.
Your Honor, I have to object at this point. He's violating the instruction, which is to talk about how the juvenile system works and SEY youth. And now we're getting into a description of the hearing for which she was not offered.
It's a prelude to why she believed that the subject minor was an SEY youth.
Again, she wasn't offered to render an opinion as to whether or not she was a SEY youth. Testimony limited to how the jury system, juvenile system works and SEY youth, not its application to this case, and that is completely separate.
Judge Polaha.
It said SEY, didn't it?
Yeah, it said how the system works in SEY youth, but not its application to this case about whether AB qualifies as an SEY youth.
And our position she should be allowed to testify as to why she believed that AB should have been classified and was classified as an SEY youth.
Yeah, I think that's consistent with the order. Overruled.
What occurred in that court that led you to believe that she was an SEY youth?
Well, generally, girls that are engaging in this behavior do not do it in their homes. They're often on runaway status, which was true of this youth. She also, when her father talked about provocative pictures, that is pretty much the way that these pimps make contact with them is via social media.
When the discussion was in reference to provocative pictures, it was provocative pictures of her, correct?
Yes.
And that was what the father articulated?
Yes, that she was posting provocative pictures of herself on social media sites.
Now, you've worked with Judge Henry, Hearing Master Henry, long enough, correct?
Yes.
Okay. And if you perceived that this was an SEY youth, was it logical that Judge Henry perceived she was an SEY youth?
Objection calls for speculation about what she thinks the judge might have thought.
I'll withdraw the
Sustained.
question.
Rephrase.
The questions, and more specifically, the directives that Hearing Master Henry gave the subject minor in that first hearing, were they directed to the dangers of becoming an SEY youth?
Yes, the fact that she was making dick appointments, to be blunt, that means she's making appointments for men to put their private part, slang referred to as a dick, but commonly, in medical terms, a penis. She was making appointments to have men put their penis into her orifices. That's what a dick appointment is.
And that's the way your training and experience showed
Yes,
you?
and when her father said that about his daughter, yes, absolutely. That, between the provocative pictures and making appointments, dick appointments, that's what that means. She was making appointments to have sex.
Ms. James, I've been limited into certain areas that I can ask you about, just so you understand that. So when I ask you about an area, it's something that Judge Polaha and the Commission has directed that I'm permitted to ask you about. So if, for example, and we acknowledge you were courteous of the pretrial with me, correct?
Yes.
If I don't go into certain areas, it's because I've been precluded. You understand that?
Yes.
And you don't have to volunteer any information. I don't want the rule violated, all right? Okay. Now, I'm going to shift over to the second hearing where Mr. Grigsby was present. You will likewise was the Chief Deputy District Attorney in that court proceeding, correct?
Yes.
Okay. And have you had a chance to view the video from that matter?
Yes.
Okay. And we're not going to play that video again, but if there's something that you don't remember, I may ask the chair to at least allow you to look at the transcript of the proceedings. Is that fair?
Yes.
Okay. It became very apparent that Hearing Master Henry was making inquiries of the subject minor. Do you recall that?
Yes.
What was the inquiry in reference to, as you said there? And how did it relate to SEY? Maybe I'll ask you that question.
Well, as I previously stated, SEY youth make their contacts not only with their pimps, but with potential dates or clients via, so often through their phones or social media on their phones. And so that wasn't unique to this subject minor. That's how, so having the phone restricted actually is part of the GPS contract that she was on. The probation officers also would have been aware of this from reviewing her files and her paperwork that accompanied her to their office. So when she was placed on the GPS, having no phone is what they have. The GPS units that our court uses now actually have a phone attached to them, so their probation officer can actually contact them via the phone, but it clearly has no social media, and the youth cannot use it to make contact with other individuals. So they're not allowed to have a phone while they're on the GPS contract.
Understood. At the first hearing, the matter was assigned for the subject minor to be represented by the public defender, correct?
Correct.
But Mr. Grigsby ended up representing her in an appointed capacity, correct?
Yes.
Did you deal with Mr. Grigsby in reference to this case?
I sent him an email on the Friday before the hearing.
Okay, to your knowledge, did you ever pick up the police reports, the discovery?
It was his practice not to.
Did you?
Objection, Your Honor. Mr. Grigsby's practice is not relevant to these proceedings, and that question and answer should be stricken.
It's relevant as to his lack of preparedness, and it's just so easy to say don't answer that question as opposed to, is there a real basis of an unarticulated Fifth Amendment?
Attorney Grigsby testified that the good faith basis for his objection and his instruction not to answer the question was that he had interviewed A.B. prior to the hearing, and she had told him some things about activities that she had done and how it related to her cell phone, and that's why he instructed her not to answer, because it may tend to incriminate her in future proceedings.
We question the good faith interpretation that Mr. Grigsby articulated, but I'll get right to the heart of a key question, and then perhaps the Judge Polaha will let me go back to this one. You've been a deputy DA you had been a deputy DA in the juvenile court system well in advance of 20 years. Do you remember any case, very broad term, any case where a subject minor has acknowledged another crime that the district attorney's office prosecuted?
No.
Why is that?
Area of the law, corpus delicti, we have youth often admit crimes in the course of their going through court proceedings, and we have a corpus delicti problem. I mean, we have a proof problem.
And corpus delicti means you can't convict yourself out of your own mouth.
Yes,
correct?
because that would be all we would have.
That would be all. So in reference to this case, where the subject minor, recognizing the subject minor was not on probation, if the subject minor was using a phone, that would have not been a criminal offense, correct?
We call them delinquent offenses, but no, it would not have been a delinquent offense.
So there would have been absolutely no ramification toward that delinquent.
No.
And I use your term, delinquent.
Yeah.
And the question I asked you was, has it ever happened? And your response was no.
Not to my knowledge.
Okay. And you would know, because you were chief deputy DA in the juvenile court system for that many years, correct?
That's correct.
I believe that in order to comply with the chair's directive, court's indulgence. Did you ever hear Mr. Grigsby use the term, "I'm afraid it would incriminate her"?
Objection relevance. This hearing is the only one that's at issue. Whether or not he spoke it in other proceedings is completely irrelevant.
Okay, in this proceeding with AB, same question.
Then the video speaks for itself.
Yes, the video does speak for itself, and we ran over this ground before anyway.
No further questions.
I have no questions.
All right, well then, thank you. You are excused.
Thank you.
Judge Polaha, we had one other witness available for us, and she was approved by you and the commission to testify, but with the court's permission, I'm going to tell her she will not be needed to testify, consistent with Your Honor's prior ruling in reference to the motion to eliminate. Would that be acceptable?
Go ahead.
Polaha, Judge Polaha, members of the commission, I'm advised this prosecution will not be needed, and as a result, we rest.
All right. Mr. Bradley, any rebuttal?
No, Your Honor, and I had indicated that in rebuttal I was going to ask to introduce the responses to the determination, but I withdraw that request, and I do not have any rebuttal, and I'm prepared to do closing in the commission's.
All right. Go ahead.
In 1964, the United States Supreme Court stated, "The privilege against self-incrimination registers an important advance in the development of our liberty, one of the great hallmarks in man's struggle to make himself civilized. It reflects many of our fundamental values and most noble aspirations. Our unwillingness to subject those suspected of crime to the cruel trilemma of self-accusation, perjury, or contempt. Our sense of play dictates a fair state versus individual balance by requiring the government to leave the individual alone till good cause is shown for disturbing him, and by requiring the government in its contest with the individual to shoulder the entire load. Most, if not all, these policies and purposes are defeated when a witness can be whipsawed into incriminating himself." Let's turn to the facts of this case. First, there's no question that an attorney can invoke an individual's right against self-incrimination, and that was cited to you in prior pleadings of Palmer versus State, which is a 2017 Nevada case. So the other point I'd like to point out is that in the United States Supreme Court decisions, no ritualistic formula or talismanic phrase is essential. So the fact that Mr. Grigsby didn't use the words Fifth Amendment, that was not a requirement. He said, "I don't want her admitting something that may get her into other trouble." That's a succinct explanation of the fact that Mr. Grigsby did not want AB to admit something that would self-incriminate her. I mean, that's exactly what making other statements that would get her into trouble means. And if she didn't want to incriminate herself, then clearly we're talking about the Fifth Amendment. And the Judge Henry's statements that she had no clue, that's what he was talking about, is concerning. So the question is, did she have reasonable cause to apprehend some sort of fear of answering the question? The courts say the inquiry should focus on what a truthful answer might disclose rather than what information is expected by the questioner. So the question is, are you using your phone at school? On the outside appear innocuous, but if in fact in answering the question, she explains that she is engaging in prostitution with the use of her phone at school, and that she's doing other illegal activities such as distributing drugs through the course of her prostitution, then although those statements may not be sufficient by themselves to subject her to criminal prosecution, as our last witness just talked about, certainly there can be an investigation and additional evidence can be acquired. And I would certainly expect that the Metro would want to investigate statements like that, not necessarily to prosecute AB, but certainly that could be a byproduct, but to prosecute the adults that are involved in criminal activity, especially prostitution, with a 15-year-old girl. So all that is required under the law is that the witness have reasonable cause to apprehend danger from a direct answer. The witness may refuse to answer questions calling for a potential link in a chain of evidence of guilt. So it doesn't require her to directly, the question can just be a link in the evidence, and certainly questioning her about her use of a phone and who she's speaking with and what crimes she may be committing with it is sufficient. And as I cited in the recent motion to amend, even questions that appear to be innocuous may nonetheless harbor hidden dangers for the unwary witness. So even innocuous questions in one case about possession of documents harbor risks. So I think the analogy of the possession of the phone is very similar. So we heard from the last witness that to her knowledge, she doesn't recall any prosecutions of cases following incriminating statements at a dispositional hearing. But the standard is not whether or not it's happened, it's whether or not it's possible. And I cited the commission to many, many cases that talk about the standard is it possible? And those cases don't talk about whether or not there's a history of it occurring or a pattern of it occurring, just whether or not it was possible. Those cases would include the Hoffman case, that it doesn't depend on the likelihood, but upon the possibility of prosecution. There's the very old Burr case where Chief Justice Marshall said there's a privilege when there's a mere possibility. The witness's last testimony does not make it impossible, just that it hadn't happened to her knowledge. But that doesn't make it impossible. So once Attorney Grigsby says that respectfully, Your Honor, I don't want her admitting something that may get her into trouble. Again, no magic words were required. The words Fifth Amendment are not required by any case law. The Fifth Amendment is clearly available in juvenile cases. The Fifth Amendment is available during sentencing. In fact, throughout Judge Henry's interview, which has been admitted in this case, she makes repeated references to the fact that she was engaging in the sentencing of the juvenile. And so I think that these cases that say that the Fifth Amendment apply during sentencing are equally applicable. One thing that was confusing to me, and I'd ask the commission to look into, is that she kept referring to the fact that she was complying with NRS 175.015, but in my legal research, I can't find a statute in Nevada that is 175.015, but again, she said she's the expert. So what should have happened at the point that Mr. Grigsby invokes her right against self-incrimination? Well, that's when Master Henry should have made a reasonable inquiry into whether or not the claim was well-founded. Instead, she keeps shouting or yelling or raising her voice, or ever how you want to describe it. Enough, enough, enough. Her testimony today that she gave him plenty of opportunities is not supported by the evidence. The evidence shows just the opposite. So she failed to conduct the inquiry each time he tried to explain, and she violated the law by doing so and did not do her job competently. And without making a reasoned inquiry, she should have at least respected Attorney Grigsby's right to invoke the right against self-incrimination. Instead, she kept pressuring the witness, or the juvenile AB, in answering questions. She continued to refuse to allow Attorney Grigsby to be heard. She took a break. Then she continued to try and violate Attorney Grigsby and indirectly the juvenile's right to be heard by interrupting him repeatedly. At one point, Attorney Grigsby says, you know, let's send this to Judge Boyd. Let him decide, and I'll do what he says. Again, that's the proper inquiry, is allowing a district court judge, not the master, to decide whether or not the invocation of the Fifth Amendment right was reasonable, and he indicated that he would abide by Judge Boyd's decision. Now, it's important to realize that when he asked for a review, this was before there were any comments about a harsher sentence being recommended by Master Henry. So I'd ask you to go through the hearing, listen to the tape, and Mr. Terry did provide a fairly accurate transcript, and the transcript will bear that out. So what happens after this break is that Master Henry attempts to coerce AB, first not to follow her as attorney's advice, and also not to invoke her right against self-incrimination. Again, I won't reread the transcript, but the transcript clearly shows how she's trying to speak over the attorney and directly to the client and interfere with the attorney-client privilege. In short, I believe that the Commission can rely on the undisputable evidence that's contained in the JABS reporting, and the Commission will find multiple rule violations in Count 1 and Count 2. I think that the respondent's position in this case is just that juveniles don't have the same rights as adults. I disagree. I think as juveniles, their rights should be respected at least as much as adults. And I think you should find that the respondent is, there's clear and convincing evidence to support both Counts 1 and Count 2. And I'm reserving brief time for rebuttal.
All right, thank you, counsel. Mr. Terry?
Is that me, Your Honor?
Yes.
The juvenile court system is not set up to punish. That is the legislative intent. It's even echoed in a specific statute. It's to help. And that's what Judge Henry was trying to do, independent of Mr. Grigsby's actions. Ms. James understood that. Mr. Grigsby was simply being volatile, disruptive, etc. One of the rule violations here is that the judge has to be courteous. That is a two-way street, particularly when you recognize that this is a hearing master, not a judge. And as a result, she doesn't have the rights of a judge. She cannot find one in contempt. She can do nothing of that magnitude. All she can do is raise her voice in an effort to try to control the court, take a recess on occasion, or use the words enough. That is her only power. She doesn't sentence. I think that that's been made abundantly clear. All she does is recommend. Special prosecutor has used the term intermittently until we get to this hearing, when he finally realizes that she doesn't have that ability and that power. So what is the judge trying to do? What is Hearing Master Henry trying to do? She's trying to help A.B. That's what she's trying to do. It was telegraphed from the first hearing when Dad used the terms that he used. Terms I won't repeat, Ms. James was even hesitant to repeat them, but that's what Dad used. Those didn't come from the subject matter. Those came from the dad. In the juvenile court system, the parents have input. They had it in this case. The subject minor was allowed to be released to go back with her parents under certain conditions not imposed by Judge Henry, but just because of the way that the system was. The testimony was risk management. Now, in all the briefs that were filed prior to these proceedings, up to and including the motion to amend the complaint, we have attempted to educate you, and I say that in the nicest term that I can, because it's become such an issue in this case, of what the validity is of an invocation of the Fifth Amendment. You would expect a lawyer to act like a lawyer, not necessarily like a thug. A lawyer would get up in court and go, "Excuse me, Your Honor, I'm going to direct my client not to answer that question because we have a Fifth Amendment right not to say that." No matter how much the special prosecutor tries, there is nothing like that in this record. Nothing like that. This is not a guessing game. Now, my colleague chose to read a case to you, and I will do the same thing, because it really sets forth the position that a district court judge or somebody in Judge Henry's position has to weigh and balance at that exact moment. And it's set forth at page 7 of our opposition to amend the charging document. I would hope that when you do your deliberations, you have a copy of this. I am not familiar with your procedures. I do not know that when I file an opposition to the special prosecutor's attempt to amend, whether that goes directly to Judge Polaha or the whole commission rules on it to seize our points of authorities. That's why I encourage you to read it. Case that's cited at page 7 articulates both the United States Supreme Court's rationale and the Ninth Circuit Court of Appeals rationale, and provides as follows. The privilege normally is not asserted properly by merely declaring that an answer will incriminate. My recollection of the video was that Mr. Grigsby didn't even say, use the word incriminate. But again, the privilege normally is not asserted properly by merely declaring that an answer will incriminate. Mr. Grigsby, I would suggest to you, was not concerned with the correctness or the incorrectness of any of his actions when he appeared in front of Judge Henry, because he knew all she could do was make a recommendation. Whatever she did was totally irrelevant, because he would do exactly what he did in this case. Before Judge Henry had a chance to articulate any recommendations, you look at that transcript or you look at the video, Judge Henry never has a chance to make recommendations. Mr. Grigsby cuts her off and says, this case is going to Judge Boyd. It's like, I really don't care what you're about to do. This case is going to Judge Boyd anyway. Now, we don't have that benefit as lawyers when we appear except under the appellate process. But this system in the juvenile court system favorably works fairly quickly. And even though Judge Boyd said, okay, 6 months, that does not mean that he reviewed the transcript. In fact, he says it, I didn't review the transcript. That's part of our exhibits. I want to continue reading that case. It says, it is not necessary that the person to whom the question has been put establish the precise manner in which he will incriminate himself. This would make the privilege useless. However, as the Supreme Court stated in Hoffman, which I would remind you was a case that my colleague just cited, to sustain the privilege, it need only be evident from the implications of the question in the setting in which it is asked, that a responsive answer to the question or an explanation of why it cannot be answered, might be dangerous because injurious disclosure could result. And that means could result in a criminal action. Judges, the witness from the district attorney's office testified to two things. One, she's never seen it happen, where there's some form of an admission in the juvenile court procedure and there is a prosecution as a result. Never. And then she said, never to my knowledge. So you've got both of those. But she also gave you a real good reason, okay? Not just the fact that the juvenile court system isn't there to punish, it's there to help, but because any lawyer knows, any lawyer that practices criminal law knows that the corpus delicti has to be established independent of the statement of the stater. So even if the subject minor said, and this was not the question to the subject minor, the only inquiry to the subject minor was in reference to the use of the phone. Special prosecutor cannot speculate on what was going to be the next question, because it didn't happen. You don't see it in that transcript where she goes, where Judge Henry goes, are you involved in prostitution-related activities? Now getting back to the citation that I was reading to you, the trial court must make this determination from the facts as well as from his personal perception of the peculiarities of the case, again citing Hoffman. If he decides that no threat of incrimination is evident, the defendant then bears the burden of showing the danger of incrimination. What did Mr. Grigsby say to demonstrate a danger of incrimination? What he said was, this case is going to Judge Boyd. So in other words, he said nothing. Continuing the quote, it is evident that the determination of whether the privilege has been properly invoked is for the district court to decide. The claimant is not the final arbiter of the validity of his assertion. That's why we make a record. Judge, I respectfully object on Fifth Amendment grounds. If there's a further inquiry by the district court judge, or in this case Judge Henry, it would be expected that he will at least say something as to what the basis of that incriminatory statement is. That is not on the record. He did not properly object. Now, we're not here to judge him, and I understand that. But you have to take the fact situation as it exists. We're all guessing, at least at the first proceeding, whether or not there was or was not a proper invocation of the Fifth Amendment right. If scholars like you and learned individuals like you and the special prosecutors have to sit here and try to figure out whether or not there was an invocation and whether or not it was proper, then at best it's a mistake on Judge Henry's part, but not one that should be punishable by this commission. She's testified before you. She does not feel she violated those rules. She gave Mr. Grigsby the opportunity to hear. She did at times say enough, because that was one of the only methods, that and taking a break and raising her voice, that would have allowed her to maintain some form of control in this type of an environment. She has a duty to sit. She has a duty to maintain control. If lawyers run over judges, it is setting an exceedingly bad precedent. The judge has to control the court. Now, I could go on, but what I've done is I've likewise, you have my pre-hearing brief that was prepared for you prior to the first, even the first proceedings. And I've taken the liberty of providing you with, at this point in time, I'd ask permission to give it to you, a closing argument memorandum. So now you have 3 sets of documents to look at for purposes of establishing what your interpretation is of the law, what your interpretation is of what a hearing master like Judge Henry's role is in the court system. It is not to punish. Even taking into consideration, if you assume the worst, that she imposed some form of a penalty on the subject minor AB, it was a 3 months extension of probation. It wasn't and I'm putting you in custody as a result of this. How dare you not respond to my question? All she was trying to do was assist the subject matter. The parents knew it, the deputy DA knew it, the judge knew it, everybody seemed to know it and care about it, except Mr. Grigsby. And no offense, you can't blame the subject matter. She's doing what she is either told to do, or she simply is not familiar with the legal system. She doesn't know what an articulatable, proper objection is. You don't have an objection in this record. So I would ask permission to provide you with this. Typically, I would ask, after we've made our closing arguments, can we file a brief? Oftentimes I'm told yes, oftentimes I'm told no. What I did is I tried to beat it to the punch. It has additional case law. My colleague will certainly have an opportunity to review it. And with that, I have nothing further to add other than to remind you that Judge Henry's indicated that she does not feel she violated any of those rules. Of course, it's office. Oh, and my colleague, I think, misquoted the side of the rule, it's 176.015. And that's the rule that deals with what you have to advise an individual of when they're entering a plea, the right to the waiving their right to self-determination being one of those things. Judge Polaha, may I have your permission?
Your Honor, if you're going to take the submission of Mr. Terry's brief, then obviously I request an opportunity to file my own brief and respond to that one.
We have no objection to that, Judge.
Yeah, that's the way it works. And this was a brief in another case?
No, this is a closing argument memorandum. I thought it would be better to put it in writing and summarize all of the cases that we've attempted to talk about. The written document is usually better than listening to oral representations.
All right, but then Mr. Bradley will have an opportunity to respond to it.
That's fine.
Judge Polaha, what's the date in which to respond?
What do the rules call for? 15 days, 25 days?
I'm cutting my own throat here, Judge, but I think it's less than that.
10 days?
Yeah. Yeah, I have 10 days, Your Honor.
Sure.
Do we have a right to respond or no?
Well, we're doing closing arguments and you want to submit a brief. I would say no, the prosecutor gets the last word.
Very well.
And Your Honor, at this point, I can save the commission some time and include the points I was going to make in the rebuttal in my closing argument memorandum, if the commission would allow that.
All right.
I have nothing further than thank you, Your Honor.
Thank you, counsel. I turn the case back over, or the floor back over to the chairman of the commission, Mr. Vause.
Thank you. Thank you, Judge, for presiding today. So that concludes the public part of this proceeding. So after we've cleared the room, then the commission will begin deliberating and considering this matter. So thank you all. And what is the timeline, Paul? We still have those two briefs back and forth, don't we? I'm trying to think of when will this be determined.
What two briefs do you?
Well,
the closing memorandum?
yeah, and the response.
Well,
I guess we'll
Bradley has 10 days to
Is this
file.
still on the record? Still on
Yeah, Mr. Bradley will get 10 days to respond. There won't be any reply by the respondent. So after the 10 days, then we should meet to deliberate.
So do we want to, while we're all here, deliberate about anything at all, or I guess that's up to us. So we'll close the hearing, and thank you, everybody.
We will thank the commission, thank you, Chris.